Hello, everybody. This is Demetris Curry coming to you with Inspired for Greatness. I'm so excited that you are here with me today. We are talking to an amazing guest today. But before we jump into that, I want to take a moment, if you would, to acknowledge and to send condolences to a very dear friend, Key Williams, that recently passed in the Montgomery, Alabama area. Literally, I truly thought about not doing this particular live today when we just got the news on yesterday that he had passed. And it is truly a heartbreaking situation. But what I want to tell the family and tell all the loved ones and the classmates in the area that is feeling his passing today, that we love you, said we miss you. We're so sorry that you're no longer here with us. But beyond that, I want to send condolences to the family and let them know that we love you and we appreciate you. He has been a beacon in the community, a genuine, more than a genuine person. And I want to take that moment before we even get started into talking about estate planning and financial literacy with our special guest, Mo, with us today. And I wanted to just stop just for a second and just give that acknowledgement and say that we love you, we appreciate you, we will miss you. And this is part of what we need to talk about. This is what we need to talk about. So beyond that, thank you so much for being here with us today. So I am Demetris Curry, president of Inspired for Greatness. If this is your first time joining us, please make sure you connect with us on YouTube, subscribe and like our YouTube channel as we do teachings with financial literacy. And I wanted to also bring this to our ladies in real estate group who've been asking these really important questions about how to use real estate in their estate planning. So I cannot move any further without bringing on our special guest. Let me introduce you to Mr. Mo. I call him Mo. You know, he said you can call him by his first name. And what I love to do is that we have been working with his firm with our clients through a relationship and through a partnership with the Alliance. And the Alliance is our partnership with our retirement plannings and life insurance and things of that nature. And I said, Mo, would you be my special guest? And he said, yes. And so we're ecstatic that that relationship of working with the Alliance has turned into an amazing relationship with Integrated Trust Systems. And now an even more relationship with Mo as being the attorney to help my clients and to assist us with estate planning and getting our things together. Mo, let me bring you on so you can say hello to everyone here with us. I'm going to give you the floor and just let you say hello to the audience.
Well, thanks for having me on, Demetris. It was a pleasure to do this. You didn't have to ask twice. Always happy to talk about real estate. Happy to talk about estate planning too. My life, my work life really lives in those two things. I am an attorney based out of the Chicagoland area. I have a real estate and estate planning law firm. I also own a real estate brokerage. I'm a real estate owner myself. I handle a lot of real estate law for investors, home buyers, sellers. I've been on a large board at the Chicago Association of Realtors. So I've been involved in real estate for a very, very long time. It's my passion piece, and happy to answer any questions anybody has and you have for your guests about how the relationship of real estate, estate planning, LLCs, and all of that works together. But yeah, I'm excited to be here. And my condolences. Obviously, I didn't know somebody that you all cared about had passed. My condolences to all of you, and obviously the family as well.
Yes. Thank you for that. Thank you for that. It was quite unexpected. I'm truly, I wasn't expecting to work on that last night, but I was like, oh my goodness. But at the same time, I heard him say they need to know this information. He was such a huge person in the community, and I said this is something he would really want the community to continue to know. So I'm going to go ahead and move forward. Let's talk about estate planning, Mo. So in the realm of trying to get your things together, when you are a husband and wife, or even a single parent, or even a business owner, what are the things to consider of whether you need a trust or if just a last will and testament is enough?
Sure. So I don't know where along the history people started to get the notion that having a last will and testament is enough. And I've actually kind of equated this. I've spoken to a marketing director. We have Scott Garcia about this a lot. And we say, where did this notion that a will is enough come about? And I actually think it came across in movies more so than everything. I was watching a Netflix special recently where it was the Menendez brothers case. And part of the Netflix special, was saying, let's look at dad's will. And they're not looking at dad's will. They were looking at dad's trust for sure. That family definitely had a trust. And then there's that misconception that to have a trust, you need to be very wealthy. The idea of a trust fund baby. That's not true. A lot of states across the country, if you have built an amount of wealth, 40, 50, 60, or in my state, $100,000, that includes the equity in your home, you're eligible for probate. So you don't have to be very wealthy to have a trust. You should have a trust. A will is fine if you want to decide where things might go. So if somebody passes away and they have no will, they have no trust, nothing at all, the state's intestate laws decide where property goes. People end up in front of the courts, and the courts will decide, depending on state law, who it goes to. Is it your spouse? Is it your kids? Is it partially your spouse, partially your kids? Is it parents? If you don't have kids and a spouse, where does it go? If you have a will, at least you have some latitude to make decisions, but a will is a one-way ticket to the probate court. So if you have a will, the courts have to probate that will. What I suggest to all of my clients is proper estate planning. And proper estate planning takes a real holistic approach to everything you have going on. So a revocable living trust is the mechanism that I would say 999 out of 1,000 of our clients use. It's what I have for my wife and my 3 boys. It's what I use for my planning. But in a proper estate plan, you have more than that. You have a revocable living trust. You have powers of attorney for your finances. If God forbid you end up incapacitated, you have powers of attorney over healthcare. You have healthcare directives. You have a last will and testament included in your estate plan. And I'll later explain why we include that with a revocable living trust. And obviously the revocable living trust itself too. So you want to have all of that handled. And especially if you have kids, you want to sit down and think about who's going to take care of them. If your kids are older and they can take care of themselves, fantastic. I have some young ones. I have a 12-year-old, a 15-year-old, and a 4-month-old. So, I have to plan for what happens if, God forbid, something happened to my wife and I. Yes, I want to make sure my assets get to them in due time. I don't want my 15-year-old to get my life insurance policy because when he turns 16, he will buy a Ferrari. And I don't want to do that. So I've created some plans so that he doesn't do that and he can get his money at a good time and in bunches. But I also want to figure out who takes care of them if I'm gone. So estate planning takes care of that entire approach. What happens to your assets? What happens to your kids? What happens to your healthcare? And that's what people should really look at. And the problem is nobody teaches it. So you don't learn it in school. You don't learn it anywhere else. Everybody thinks, oh, I'll just wait and I'll wait. And the problem with waiting, unfortunately, is we don't know when, our time is up. Nobody knows. It could be today for me. It could be 50 years from now. I hope it's 50. I hope it's not today, but you just don't know. So a lot of times people wait till it's too late. And at that point, then you can't really create that estate plan anymore.
That is so true. That is so true. You just said so much in that paragraph there.
Yeah, we can digest it.
Oh my God. So let me break this down just a little bit more. So what you're saying is that with the will itself, it's a one-way ticket to probate if it's by itself.
Correct.
And so for those people that tell, or maybe they get counsel that say you don't really need a trust, you just need a will, but they have all these assets and all these properties. That's not the best guidance, right? So
and I don't want to interrupt, but I don't want to say all attorneys are bad because they're not. I'm an attorney. I have a lot of friends that are good. Part of the problem is that a will is very easy to create. So a lot of people who should not be doing any sort of estate planning just create a will because they can say, hey, come to my office. It's really a form. They'll put it together. They'll explain to them what it is. They'll charge them a fee, send them on their way. The reality is that what ends up happening is those people need probate again. So down the line, when somebody passes away, they come back and there's a probate case. And probate is just that long drawn out court process that decides what happens to your things if you pass away and you don't have a properly funded trust. And it's more expensive than the creation of a will. So some law firms realize that at the end of the day, something's going to come back to them in probate that way. And I don't want to say that's across the board, because I think there's a lot of good attorneys out there, but I think good attorneys that know what they're doing are trying to set you up for success, not just to now, if you have nothing at all and you don't want to do an estate plan, at its very minimum, you should have a will. But I do think that that is just a step in the right direction. You don't have the entire plan put together with a will.
Right. So let's dig a little bit into probate, if you don't mind. Sure. How does probate actually work? So when you go into probate and you maybe you don't have a will. Let's say you don't have a will at all. Right. How would probate work?
Well, so if you don't have a will at all, every state has a little bit of a different law. It's their intestate laws of how property gets determined and where it goes. And a little bit of that is dependent on who you have in your life. Obviously, if you have a wife, they look to that. There's hierarchies of where things go. If you don't have a wife, but you have kids, it potentially goes to your kids. And if you don't have either and you have parents, it might go to your parents or your siblings. So that's, the court decides who you have and how the property is going to get distributed. Now, you end up in court, you got to pay some court fees. Most people opt for an attorney. You have legal fees. It's long, it's lengthy, it takes a while. Let's assume you have a will. The idea of the will is that the will has laid out some of your intentions. So we're going to go based off of some of those intentions, but the court still has to probate that will. If somebody has an issue with the will, if somebody thinks that the will was done improperly, they can come into court, try to lay a claim to that. So sometimes, and this is an awful scenario, right? People pass away and then, families fight. A fight ensues over, somebody's belongings. I just had a scenario here in Chicago. I was actually on the real estate sales side of it as an attorney, and two sides were fighting. And there was not a lot of equity in that property, but the two sides just fought. The two sides of the family. And the probate fees just kept going up and up and up. And what ended up happening at the end of the day is the entire family just ended up losing almost all the equity in the home. And it was because there was not a plan in place laid out by the person who had passed away that said, this is my intention, here's my trust, this is what needs to happen to these properties. And that infighting that happens a lot of times, I'm sure you've heard of somebody who's lost somebody and then the family members got into a fight. A proper estate plan will alleviate most of that fighting because the plan is there and the courts don't have to probate that will. So I'm a big proponent of, if you care about those people who are your beneficiaries, the people you're leaving things for, you don't want them to have a hard time gaining your hard-earned assets when you pass away. And you don't want to set them up to be fighting or have a reason to fight when you leave, because I don't want that to be my legacy. I don't want to leave and then my kids are fighting, or if I'm leaving something to family and kids, they're fighting over it. I just don't want that to be what happens to me. And I also don't want uncertainty of what happens. So I have a very specific plan. Like I said, at the beginning, my kids get their funds at certain ages. They don't get it when the court decides they can just have it and it's theirs. I don't want even an 18-year-old kid of mine to come into a lot of money. I don't want them at 21 to come into money. I know what I would have done. I know what I would have done at 18 or 21, and I was a pretty responsible guy.
Right.
I have it set up so that over the course of time, I set them up for success. So that is a really important thing that people have to keep in mind too, is, you're not controlling everything from the grave or, wherever you believe you go, but you have some control that everything you worked hard for gets into the hands of the people you care about at the right times and in the right ways.
Absolutely. And you can actually dictate how they get it.
Yes. Yeah.
More importantly, how they get it, as far as if you're not getting in lump sum versus chopping it up over certain years, which is what we did for our son as well, is making sure that he couldn't get at one time.
You don't have to do that. I have a lot of clients whose kids are 45, right? And they say, we trust our kids. They can have it whenever they want. We pass away and let them have everything. Great. You can do that as well. But the nice part about a proper estate plan is it looks into your life situation, your life scenario, and thinks about that for you, as opposed to having a blanket form that's kind of fill in the blanks, like a lot of times a will could be.
Right. One of the things that, when we sit down with the client here at Inspire for Greatness, and thank you so much for being our backup attorney to send our clients to and work with. I've seen so much of what you've done with our clients, and I've read the information, all the things that you put into their trust, and quite detailed. I love it, on what they need to do, making sure that legal language is amazing, right? But one of the things that I always have people ask me is like, well, should I or should I not just add my child onto my real estate? I mean, versus just doing a trust, why not just add them onto my mortgage or something of that nature? How does that impact them if they were to add a child or maybe a sibling onto the mortgage versus doing a trust? How would that impact them?
It's a big risk. So let's assume the idea of you have your home, you're living in it, and you say, let me just add my son to the deed. Let me quit claim deed this to ourselves and my son, setting aside some miscellaneous little deed transfer issues that could potentially occur. What happens if a judgment gets rendered against your kid? I'm going to use an example that everybody can relate to: texting and driving. I'm guilty of it. I mean, I work all day. I wish I didn't do it. Sometimes I do it. If I'm texting and driving, and I remind myself of this all the time, and I, God forbid, hit somebody in a crosswalk, I'm going to knock on some wood, that never happened. And I go judgment against me, and your kid goes and let's say I'm your kid, and that happens, and he's now got a judgment and a big one against him. And you max out the insurance, it doesn't cover it. Now this kid has a judgment that's going to attach to your property likely. And what's going to happen is you've worked really hard. You built this equity in your house. Maybe it's almost paid off. And now somebody else did impacts you. Or you end up in a scenario where there's a divorce happening, and this is an asset that the court thinks that person now owns. Yes, maybe you work around by saying, they didn't use any of their finances to purchase that property or become a part of it. But I'll tell you what, good divorce attorneys are going for it. They're going to try to trade something else for the fact that you have some ownership share in this property. So you have to be very careful with that. When somebody gets a judgment against somebody, they can attach it to things like bank accounts, homes, assets that you own, and you don't want to take on that risk. You might love your kid and he might be doing everything right. I don't cause any trouble in my life. I pay my bills. I do everything. Accidents happen, and accidents can lead to judgments, and those can really impact you. So why take on that risk when there's a better way to do it? You can still leave things for your children. You can still leave things for your beneficiaries, wherever they may be, without taking the risk of them potentially impacting your financial future while you're living.
Oh, yes. Oh, yes. I had a client that we did a trust with last couple quarters. And he said, you know what? I never really thought I needed a trust. Quite honestly, my children are well off. They're doctors and they're doing this and they're doing that. He said, but I have a lot of assets that I've built over the years that I plan on just leaving to them. And I was just going to put their name on it. But then he thought about it. He was like, oh, wait a minute. Did you just tell me that if my son, who is a great physician, goes through a divorce and I've left him all these assets in his name versus being in a trust, that his wife gets half? Is that what you're saying?
Potentially. Inheritance in a lot of different states doesn't get played into divorces. But here's the problem. Most states also say that if you take inheritance, but you commingle any of those funds into the marital funds, they can get tapped into. So it's very rare. And I'm not a family law attorney, so I don't pretend to practice it, but I've seen it happen where somebody does have some sort of inheritance money. Now they've commingled it, and the divorce courts do turn around and say, well, we want a part of that for our client. And people get divorced. I mean, there's the divorce rate's the divorce rate. It's 50%. You look around the room you're in, half the people who are married are likely going to end up divorced. It's a sad reality. You don't want that to impact you. And again, it's when you're estate planning, if I had $1 every time somebody asks me, how do I keep my son's inheritance out of my daughter-in-law's hands or vice versa? And you may love your in-law. It might be something you love them. You want to account for them. Proper estate planning does that.
Right.
If, in my scenario, if God forbid I passed away, my kids, if they're married, their spouses don't get anything unless my kids want to give that to their spouses. It's up to them. The trustee is my sister. She makes sure that the money's held for my beneficiaries. Right. So, the spouses aren't going to take anything away from my kids should I pass away, unless my kids want to give it to them. And then fantastic. You want to give part of your inheritance to your wife. God bless you. But I don't want it to go into their hands without my child giving them that opportunity. Again, if you don't properly estate plan, that is an outlier situation that can happen.
Right. Absolutely. Absolutely. In the realm of real estate, you're very big in real estate as well. You have all these rental properties, several LLCs for all of your businesses and things of that nature. So you know exactly what we're talking about when we're talking about how to build out your real estate, your rental properties, your LLCs, and your trust. Is it okay to put your LLCs under your revocable living trust, or do you need to do something completely different for that?
Good question. So you can assign membership interest of an LLC to a trust. What I don't like to do is I don't like clients or myself or anybody I know owning investment properties in their own name. The reason is the liability is high. People slip and fall. People are litigious. I live in a market where tenants have a lot of rights. Across the country, landlord-tenant rights are a little bit different. But the transitions happening almost everywhere to giving tenants a little bit more rights. So lawsuits happen between tenants and landlords, and sometimes they impact the landlord. I don't ever want assets in your own personal name that are being rented out. Why? Because God forbid there is one of those bad worst case scenario situations at one of those properties, a slip, a fall, someone hits their head, insurance for whatever reason denies you. If there's a judgment, it impacts that property and only that property. Now, there are people that say, I want to own 20 properties in one LLC. You can. It does. There's nothing that avoids you or restricts you from doing that. However, know that if one thing goes wrong at one of those 20, it can impact all 20. It can go after the assets of that LLC. So what I like to do is separate properties, separate LLCs. Now, accountants will hate you. Accountants hate this piece of advice, or maybe they love it because they can do more returns and they make a little bit more money. You keep them a little bit busier. But overall, single property in an LLC. Now, if you have a 4-unit, all 4 units can be in one LLC. But if you own 123 Main Street and you own 456 Main Street, you're going to have 123 Main Street LLC, 456 Main Street LLC, or whatever you want to call it. They each individually own that asset. Then you assign your membership interests to the trust itself. Now, if it's not an LLC that owns real estate, and let's say you have two members in LLCs, we call them members, and you guys are working together. You can, as a membership, as an LLC, as members, decide if you do want to allow transfers of your membership shares to a trust. If the answer is no, there's workarounds. You can buy key man insurance on one another and then assign that to your trust. I have one business with a partner where at the time when I created it, he definitely didn't want to have to run it with my then mom, who was my beneficiary. Now my wife is, and I didn't want to run it with his then wife, who's now his ex-wife. They're part of that 50% statistic. So what we said is, if one of us passes away, our shares go to the other member. But we work really hard in that business. I don't want my hard work not to be able to go to my family. He doesn't want his hard work not to go to his family. So we bought key man insurance on one another, and that's what will pay our family members. So there's a couple different ways to do that. So that pays into my trust, and or the company will pay that into my trust. So you can assign your membership shares if you want. You don't have to. And then you can also have a succession plan through your LLC's operating agreement. An operating agreement for an LLC is like its partnership agreement. So you can craft whatever language you want. Now, 9 out of 10 LLCs allow the transfer of those membership interests. It's rare that you don't allow that. So what we do when we're looking at somebody's estate plan is we say, what do you own that is a LLC or an Inc. or a corporation? What do you have that is a business? Let's see what the best way to assign those interests to your trust is without creating any sort of personal liability. Because again, what we're trying to do is a revocable living trust itself does not give you any creditor protection. It's smart planning of all the assets you own that creates protection for you, because a revocable living trust in and of itself is not going to give you creditor protection. It's not there. It's not a mechanism that does that. But if you are smart about how you own assets and businesses and smart about how you transfer interests, then you have some layer of protection there. Right. And obviously, then you can still decide, with a normal revocable living trust, where those assets end up going and to who.
Right. And it's in the layering of everything of how you get even more protections in there. We're starting to get some questions too.
Good. I don't see any of the questions, but fire them off if you want. I can't see.
Yeah. Here is one from Let's Learn. She says, or he says, how do my assets remain an asset after I am gone? Where do the repairs and the upkeep continue on the property if something should happen while I have young children?
Good question. So let's assume it's your primary residence. Let's talk about that because that's what I think it seems like this fact pattern is leaning towards. So you pass away and there is a piece of property. Well, your trustee, who's the person who is going to kind of control what happens with the funds for your children, can make some decisions. They could sell the property and then put that money aside for the children. If you have children and they have a guardian, that guardian potentially is your trustee. They can move into that house. They can move the kids into that house, take the proceeds of that home and add it to the value of the estate trust value that your kids will have. Or they can opt to use the rest of the finances within the trust itself. So let's say you have a life insurance policy, you have bank accounts to help with the upkeep of that. So there's really 3 buckets of roles in a revocable living trust. There's you, the creator grantor, who is leaving everything behind. But when you pass away, so the last of the grantor to pass away makes a revocable living trust irrevocable. So it's revocable till you die. The moment the grantors have passed, the trust becomes irrevocable. No changes can be made for the benefit of the beneficiaries. But there's a supplemental role in there. The third role, so you got the grantors, the beneficiaries, third role is the trustee bucket of roles. That trustee, the power of attorney. That's the person who's going to help figure out, do we sell the property? Do we keep it for the kids? Now you can have rules there. You could say, hey, upon my passing, I'd like this home to go to, my son, Tanner. And if Tanner is 15 years old, like in my case, the trustee would, figure out where he's going to live in the near term, maybe rent the house out, give him to him when he's a little bit older, let him live there. The guardian can live there and then utilize some of the rest of the proceeds from the estate to be able to take care of those repairs, the updates and everything else. It really just depends on the age of the person, what you want done with the property. And we can be pretty creative with what we call custom trust language, custom trust directives to figure out, in your case scenario, what happens. If it's a motor vehicle, maybe you're selling it and you're keeping those proceeds and splitting them equally between the beneficiaries, or maybe it's an antique vehicle. I'm a car guy. Sometimes I have friends that have cars. They say, we want that car to remain for our kid when he turns 18. Well, the trustee will figure out how to use proceeds from the estate itself to make sure that car is running at the age of 18 and hand it off to your kid. So depends on the asset, depends on what you want done with it.
So in this particular case, like if they want to, this will be a custom directives where when we do when we start implementing the trust and we send you the data when they sit down with us and we send that over to you, we put in these extra details like this that say, hey, I have some properties that I want to pass to my kids and they're young. So if I was to pass now, how do we keep that property going and upkeep and things of that nature? So we add that into your custom directives information.
And that's why we call it estate planning. It's not there's an idea of what we want most people to do for some things. And we give those suggestions. And there's some things that the law allows us to do. But it's planning because we can get pretty custom with what you want done for your life's needs. So it's estate planning and it's an actual plan. And how we do it is it's multiple steps of the process. We discuss funding because you have to have a properly funded revocable living trust. We'll implement some of those custom directives during the legal review calls. We go through those directives. We try to figure out exactly what it is that you want and need. And if we can add something in there, we will. We have people saying, what's going to happen to my pet when I pass away? Who's going to take care of him? How am I going to leave them money to take care of my pet? Because, I have a Chihuahua that goes to the vet every 2 months and I need something left there for that pet. We get as detailed as that. What's going to happen to my gun collection? I have a collection and I don't want it to go to my kids. I want it to go to my brother or somebody else, or I want it to go to, a neighbor. So the estate planning is legitimately a plan. We look at your individual cases and then figure out what we can do.
I gotcha. And here's a next question. Let's see here. Should you put your residential LLC into revocable trust? It would be better to leave it, or it would be better to leave it separate.
I assign my membership interest in my LLCs to my trust. So the properties are held in separate LLCs. Membership interests are assigned to the trust.
Yes, yes. I do the same thing. Here is another question here. Is it wise to transfer the interest of the business to a beneficiary rather than the business individual assets?
Depends on the business. That's a very loaded question and a very good question. So again, part of the planning and a little bit of the background we do real estate, we do estate planning, we do some corporate law too. Depends on the business itself, depends on business liabilities. There's some businesses where the assets are very minimal, but the value of the business is potentially relationships. Contractors are very much like that. Sometimes you'll have an HVAC business, big money. They gross a lot of money because they have a big client business. But what is their actual asset outside of that? It's a truck and a couple tools. So not a lot of assets there. So you're assigning something more tangible, like a business list instead of a motor vehicle. So it depends. And again, good question. And I don't want to keep reiterating this, but a part of the planning. And it's very different depending on which business you have. And again, sometimes some businesses, if you have a partner, they don't want to transfer. They don't want to allow you to transfer that. So what do? We think of other ways to make sure that your beneficiaries can benefit from your hard-earned work by suggesting things like key man insurance and things that, will allow your beneficiaries to gain some of that value of the hard work you put in for 10, 20, 30, 40 years. And then your partner not being stuck running the business with potentially your trustee or, your kid. My business partner doesn't want to run my business with my 15-year-old or, God forbid, my 4-month-old. Eventually, he wants to be able to have latitude to do what he wants. But I also don't want, zero to go to my family because I'm working really hard day in and day out on my business. So again,
you made a really good point. Really good point. Really good point about you don't want to leave the business to your partner to be like a 15 or 16-year-old, right? And the key man is really the way to go. I do allow that with our clients as well, to do a key man to make sure to protect just a part of going to the family. What portion goes to the family, key man coverage when you're a partner within a particular business. I think that is a very strong method of doing it that way, especially if you're not sure what's going to happen with the business. Real estate business, even if it's a commercial cleaning service, you just don't know if that partner's going to want to hold on to it in the future.
Well, and who knows? Sometimes partners are opposites attract. Sometimes, and that's how magic happens in businesses. Sometimes the business is not going to be as effective when you're gone, and the valuation is going to dip. And maybe the person you're leaving the business to doesn't have your tool set, doesn't have your business acumen, and it's not for them. And sometimes people who are kids, I'm an example of it. My dad is a very successful physician. He's worked his whole life, loves medicine. I'm sure his dream was for me to be a doctor. I let the poor guy down. I went to law school instead. But it's because I didn't want to take on that business. Now, he's in a very particular business where you can't really own a medical business, physician's office without being a doctor. So I really can't share in that business. But your kids might not want to do what you do. And you have to think about that sometimes. You don't know when they're young. I don't know what my 4-month wants to do. Right now, he just wants to scream at 3 a.m. That's his only goal right now. But I don't know what he's going to be. But as your kids grow older, it's possible they just don't want to be a part of the family business either. And that's something that as time goes on is fluid. And again, the true benefit of a revocable living trust, outside of the fact that you avoid probate, is that by its definition, it's revocable. It's amendable, it's changeable throughout your life as much as you want. Our platform is great because it allows you to do that without having to pay a consistent attorney fee. So it's really bespoke in the sense that I don't think there's another platform out there that allows you to make changes continuously as your life progresses. But that's one of the true benefits. Your life is going to take you in different directions. You'll have new businesses, you'll have new bank accounts, you might have new beneficiaries, you might have a new wife. Hopefully you don't have 2 of them. You have the second one. But your life is going to take you in different directions. You might have, a gap between your kids, and now you have to think differently. The revocable living trust allows you to make those changes throughout your life. So if your kid becomes 17 or 18 and says, Mom, Dad, I want nothing to do with this, and he's your only kid,
right,
maybe what you assigned to the trust completely begins to evolve into something else. But that's a benefit of having a revocable living trust. you can make those changes throughout your life.
Right. And that's very
important. That it becomes irrevocable. Upon your passing, now people can't change it because your wishes are locked into place. You're gone now. But throughout the duration of your life, you can make as many changes as you want.
Absolutely. Absolutely. And that's important. And you touched on something that was really important. And that is one of the partners that you and I both have together in the integrated trust systems, of being able to have a trust that you can make unlimited changes to without being able to go to another attorney and paying $300 to $500 an hour each time you have to make a change. You talk about expensive over a long period of time. That's the part of the quote that they don't give you, because they don't know how many changes you're going to have in your lifetime.
Well, that, and also what integrated trust systems does is it makes it easy and it makes it inexpensive to make those changes. So you don't feel bad making changes. You don't put them off. So listen, I'm a law firm. I love attorneys, but here's how it's normally done. You go to a law firm, you get a revocable living trust, all the ancillary documents that go along with it, the powers of attorney. They hand it to you after they've signed everything, and they say you have to get it funded. And then if you need us, come back to us. We got to make changes. Well, like anything else, going to a law firm, even if they're great and they're fast, they're going to charge you hourly for those changes, or at least they're going to have a flat fee for certain changes every time you go back to them. But it's going to take time. And you're going to set up a time to consult with them about the changes. You'll request the changes. They'll have you back in the office, a couple of weeks later at best, and that takes a long time. With integrated trust systems, you can go change it yourself in 5 minutes, or you can put a note in what they have, the Notepad Center, and say, hey, I don't know how to change this account. I don't know. I want to remove a beneficiary, or, I want to add a beneficiary. I just had a baby. I would like to change my trust to add a beneficiary. Mm-hmm. You put that in the Notepad system, which is, where the client goes to ask questions or ask for assistance. Within 24 hours, that's done for you. Sometimes within the hour, depending on how quickly the staff can get to it. But, you have changes done within an hour and it doesn't cost you anything. So that the world is going in a direction where we can do these things more efficiently and effectively, and integrated trust systems is at the forefront of doing that. It's the only platform I know that does it. That's why I've partnered with them. I'm working with them. I truly believe in what they do is going to make it more efficient for the client, less expensive, but also, again, set the client up for success with funding their trust, because that is an element that people miss often. Mm-hmm. So, my trust and my law partner, Tim, we talked to each other before we got involved with integrated trust systems. And I called my law partner, Tim, and I said, Tim, I got a question for you. I'm just going to ask you one question. Because he said, how did the call go with integrated trust systems before I joined? I said, it went fantastic. I love what they do. They do some great stuff that we're not doing. I said, but I'm going to ask you one question. And this is an attorney and a very good one. I said, is your trust still properly funded? And he laughed. He said, I don't think so. I said, so your wife would end up in probate? He said, yes. I said, yeah, mine too. I said, and we're going to stop doing that, because the vast majority of people, and it's not the law firm's fault. The law firm doesn't have the manpower to stay on top of you for funding. They just don't have it. And they don't want to take on the liability if you forgot to give them something to, deal with their legal malpractice and all the trouble that comes with trying to keep a trust funded for the client. So what do? They hand you the documents. They hand you a letter typically that says, keep your trust funded. If you don't, you will end up in probate. So when I realized that integrated trust systems was doing funding, they were making it easier for the clients, I just said to myself, I cannot do this stuff in an archaic way anymore. So that's why I got involved, and I'm both feet in.
And that's how you and I partner, because of the collaboration that we too have with integrated trust systems, and the partnership that brought you on with us is through them. And so we're very appreciative of the platform itself and helping the community all over the nation of what they're doing in estate planning. We have another question here. We're going to touch on that. And we're going to also add information here in the comment section. And if you are looking into doing your estate plan and either want to do a one-to-one consultation with my office, Inspired for Greatness, where Mo would be your backup attorney. Hello. Make sure you put that information in there at the very bottom.
I'm going to give you props before the question. And I'm not doing this because you had me on, but I deal with advisors. I deal with people who bring on estate planning clients all day long. Hundreds of people that bring people to the platform. Demetris is one of the most hardworking, knowledgeable. Very few people take the amount of time she does per client to understand their needs. I mean, you go above and beyond of understanding exactly what we just touched on, the plan piece of things. And it's important because what we're doing is not, when I do a real estate sale or a transaction at my law firm, yes, there's an emotion involved in that for sure, right? You're selling a house. There's, especially if it's your own home, there's some sentimental value there, but it's a transaction. It's a business transaction. That's what's happening at the end of the day. Somebody's selling, somebody's buying. When you're estate planning, you are planning for some very sensitive scenarios. It's your family, it's your assets, it's your kids. Sometimes it's your kids who have special needs. And you take a very, very, not just interested approach, but a very sensitive approach to all of your clients. And it's important because people don't want to feel like the most sensitive part of what they're doing is handled by somebody who doesn't really care. And you always show that you care. And that's what it is. It is a difficult conversation to have. All of us are going to pass away unless, we get turned into AI robots in 20 years. We're going to be gone. And we just don't know when that's going to happen. So it's inevitable. It's a difficult conversation to sometimes have with loved ones and family members. And having somebody who is caring hold your hand through that matters a lot. And I do want to applaud you on that. You do a great job of that.
Thank you. Thank you so much for that, Mo. Thank you. You and I both know that I have a special needs brother as well. And so, dealing with that and making sure, my mother-in-law has dementia. It was so many things that we had to do for our own estate planning. So, I dig deeper than just what's on the surface because I'm going through the same thing. I am a person too, right? Going through the exact same thing of making sure, and then all of our real estate, how do we put that in the right way? And, does it go underneath the trust? How do I make sure the interest of my real estate moves to my son who is still a juvenile? All those great questions that I had as an investor into residential properties and commercial properties. And then, my own home component inside the home. How do I do this? What do I do? So that was very important for me. So I wanted to, when we brought this on from, Inspired for Greatness, just not doing the real estate commercial lending and also doing, the insurance and estate planning on that. When we brought this on to be a component in 2024, to be very important, we didn't realize how many of our clients needed it. We had no idea, but we were seeing some people say, hey, I got all this property, now what?
9 out of 10 people don't have a trust. If you look around the room, half are going to get divorced, 90% don't have a trust. I mean, that is the unfortunate reality. And it's put it on the bucket list of things that schools don't teach, universities don't teach. You're not going to teach it to a high school kid. It's going to go right over their head. But by the time you get to, college, it should be something taught. It should be something people talk about. And I think people don't understand it. And because it is very intimate and bespoke to your scenario, it's sometimes hard to explain. You've been involved in it for a while now, so you intimately understand it. I understand it, but it's intimidating to a lot of people. But everybody should think about it. It doesn't make sense to allow attorneys and probate courts to make money and your family members to fight when you're gone. And even so much as your medical directives. I mean, I can't see a raise of hands. Normally, if I'm in a room, I would say, show me by a raise of hands how many of you have actually laid out medical directives for yourself. What do you want done when you end up in a hospital and you can't speak? My dad spent 3 months in the hospital this year. 2 of those months completely unresponsive. He couldn't speak. He couldn't get into his iPhone. If you don't have medical directives when you end up in those scenarios to, figure out what's going to happen for your care, you put your family in a very tight spot there to have to make medical decisions on your behalf. Have you thought of, what happens in that scenario? Who's going to be the person to make decisions for you? Because again, accidents happen. I dropped my son off at school today, drove back. There was a massive accident on the highway. And, it was a really, really bad accident. And I was actually thinking going by, I was like, I hope everybody's okay. Those people, when they left their houses this morning, had no idea they were going to be in a car accident today. Stuff happens, and hopefully they're all okay. But if they are in the hospital, having an idea of what happens to you when you're in those scenarios and giving guide points to the people you care about so they're not in a difficult position is also part of estate planning. So it's not just what happens to your stuff. It's what happens when things go wrong for your health as well.
Exactly, exactly. And I'm so glad that with what we do, with pulling everything together and doing the intake and preparing the package for you before we send it over to you from the client, I'm so glad that we include those power of attorneys of how to make sure you have a financial power of attorney, someone that can speak for you in the event that you just can't speak for yourself, but you need them to do some things for you while you're in the hospital or incapacitated or whatever it is. You need to make sure that they can still speak for you and do your transactions for you on your financials with that financial power of attorney. Same thing with the healthcare. I mean, goodness, how do you tell the doctors you don't want a blood transfusion if you don't have it in your medical directives?
Yeah. And leaving it to guessing. I'm going to tell you my personal story. My dad had a healthcare power of attorney. He had minor directives, but not major written down. And this was prior to my association with Integrated Trust Systems. And I was left with the decision to either put him in hospice or emergency life support transport him. Mm-hmm. In that moment, and to date, it's the most difficult decision I've ever had to make. I made the decision to transport him. He couldn't speak for himself. I'm not a doctor. I had one hospital and one doctor telling me there's nothing I can do for your dad. He's going to pass away. I had another doctor somewhere else saying there's something I can do for him. Bring him to me. And I'm stuck here thinking, am I going to make a decision that's going to put my father in a really bad spot? Because one doctor was saying, if you get him there, he's not going to make it, or he'll be a vegetable, and you take that into consideration. And I have somebody else saying I can help him. If you have directives for your family to have to make that decision for you, you make it easy on them. If not, they have to make a decision. I made the decision to transport him. My decision has led for my dad to be on a trach and a ventilator, and he speaks. He actually goes to work now. He's in a wheelchair, and he's an exceptional man. I sometimes think, did I, make that decision and make his life difficult? He tells me no, because he's my best friend, and I love him and he loves me, and he'll never want to make my life difficult. But those moments, those are the most difficult decisions you'll ever make in your life. Right. I can tell you that 5-10 minutes of trying to figure out what I needed to do was definitely the hardest thing I've ever had to do. Mm-hmm. If you have directives in place for that, people can take care of you. Or you end up unconscious, we provide a medical ID card where somebody can log in and actually see your medical directives in real time. What if you have an allergy to a medicine? If you're knocked out, you can't tell the first responder that. They're just taking a guess. Or what's your blood type? I put my blood type in my directives. If I need blood, I don't want them to guess. It says my blood type is A positive. I don't want them to take the time to test. They're not going to guess. They're not going to just say, hey, give me a vial of blood. But I don't even want to wait for the test. My directives say my blood type's A positive. Give me blood. So there's a lot of things that you can plan for, because again, when things go wrong, you just don't know when that day is. And in those moments, who is going to be struggling? If you're unconscious and you don't know you're fighting for your life, you might not be aware of what's going on. Your family is under a lot of pressure. They're under a lot of stress because they love you. Make life as easy as you can for them.
As easy as possible, as easy as possible. We have 2 questions from this caller. Let's see here. We have, how often should you review your estate plan aside from when there are major changes? And then she mentioned, what does it mean exactly to fund a trust?
Love that question. Both questions, actually. So funding is a little bit different depending on under what state laws you're creating your trust. There's different rules, regulations, but basically what we do is certain assets will assign to the trust itself. We have a specific way of doing it in Integrated Trust Systems. We use Nevada law. You can use the law, by the way, of any situs of any state to create your estate plan. Reason being, we are mobile creatures. So if I want to leave Illinois, go down to Florida to retire, although they didn't do a good job of motivating me with their hurricanes this year, it would be unreasonable if I had an Illinois trust to then have to create one in Florida. They would have the full faith and credit clause of the U.S. Constitution forces them to acknowledge it. So we created under a law set that allows a lot of leniency, both for the grantors and the beneficiaries. So we have an assignment method of funding, but you want to assign assets to your trust, whether it be we're quit claim deeding a home to a trust, assigning bank accounts to the trust, assigning life insurance policies to the trust. You have to add assets to the trust. We use the assignment method of funding. It works. And it makes it easy in our scenario for you to stay on top of funding instead of having to go and retitle every single asset you own, which is cumbersome, which takes me to your first-ish question, which was how often do you review it? Well, I do this. So my revocable living trust right now, the actual trust language itself, is stationary for a little while. Why? Because I have my 3 boys. My sister's my guardian, and I know what should happen with my trust. God forbid my sister, passes away. I got to think about, next steps. We have a secondary guardian. Maybe that's first, but then I have to think about that. So if something happens in your family where, you have to remove somebody, add somebody, you're going to make some big changes, or somebody new pops into your life and you want to add them, or there is a charity you want to add. You can always add that at any time. What I always tell clients you want to stay on top of is the funding element. So if you open another bank account, let's say, and it's a mental note for me, open a bank account, assign it to the trust, buy a new car, remove the old car from the asset inventory ledger, add the new car. And when we go through legal suitability review calls with our clients of the system, we actually talk about that. Hey, what are the periods in which you should come back and make changes? Is it when life takes you in a different direction? Yes. But it's also when potentially your assets change, because assets that you don't properly assign to a trust fall outside of the revocable living trust. They potentially are eligible for probate.
And see, and literally, and funding the trust, and I think the word funding makes people a little confused.
You don't have to add money to it. You don't have to say,
no,
I'm
going to add
$10,000 to this trust. You could assign $1 to it from your bank account if you want.
Exactly.
Signing stuff to it. It's not, you have to go and dump the money physically into another account. That's not what we're talking about. And yes, that term of art is sometimes confusing to people, but we make it really easy. The online platform, it's the easiest I've ever seen for that element of your trust. And again, let's say you have a bank account at JP Morgan Chase, you haven't assigned it to a trust. That's eligible for probate potentially. And you want to just make sure that as your life progresses, you do a little bit of audit of yourself, really. Did I add any accounts this year? Sometimes it's the end of the year. At the end of last year, I did start to see a lot of people were commenting in the Notepad Center, hey, I added this or I did that. And it may have just been a mental thing at the end of the year. They're thinking about what they did throughout the year and they're coming back. The nice thing with the trust is, with the Integrated Trust Systems platform, is you can do it at any time. I go open a bank account today at Chase or Bank of America. I can come and assign it to my trust quickly. Today I could do it instead of having to wait and, potentially I end up in that accident later. So time is always of the essence in everything you do. But, I'd say at least once a year, do a mental note, or if you're on top of it, where I am, open a new account, buy a new car, assign.
Yes, that's what I do. So as soon as there's a change, so I go ahead and add that new account or whatever.
You don't need to worry about it day to day. And listen, some people are of an age and or a place in their life. It doesn't even have to be an age where, hey, my kids are grown. I'm not going to add any more beneficiaries. They're going to get their funds right away. I'm not worried about, giving it to them over the course of time. And by the way, the accounts I've had for 20 years, I'm not changing a thing. You may never go back in and change another thing in your life, but you can if you want. And that's, different strokes for different folks. Some people will do the trust and then have very little to do throughout their lives. And there's people who are in there. I see it every other month, adding something, subtracting something, changing something with their scenarios. And that's the benefit of the revocable living trust, is you have as much or little latitude to make changes as you want.
Absolutely. So let me throw a question at you as we have about 6 or 7 minutes left in this session. I want to throw one question at you that I just received on yesterday. And I think it was a very, very important question. So we have a husband and wife that basically had children outside of their marriage and came together. Okay, so they're coming from a blended family, and they have inherited properties from previous parents that may have passed and left them big lumps of real estate from them. Do they have to do a trust together, or can they keep a separate trust to keep the inherited properties from their parents separate to roll down to their biological children?
Good question. So I have my 2 oldest are step boys. I call them my sons because I treat them just like my own sons. So I have blended situations. In my situation, I have a co-grantor trust with my wife. Everybody's getting things equally. Maybe I have more inheritance than she does for sure, but we're co-grantors. But That's not the only way to do it. I have a lot of clients that come from blended families. They already have kids on both sides. They're not going to have any kids together. They want to be very specific to where things go. And maybe they are still accounting for the other kids or one another, but we suggest to them then have a sole grantor trust each. And you can account for each other. You can account for one another as husband and wife. You can account for the step kids or, parts of family members. I can account for my wife's sister if I wanted to, or whoever I want. But the idea of having the sole grantor trust, it works really well there, because when the sole grantor passes, that trust becomes irrevocable for the benefit of all the beneficiaries they put into place. And sometimes, I don't want to say people don't trust each other, but with a co-grantor trust, the reality is if one of you passes away, the other has a lot of latitude to make changes to some of those assets, change the way they're distributed. So I always suggest if it's a true blended situation, you're both bringing a lot to the table. You're both very worried about where that's going to go when you're gone. Let's each create a trust, a sole grantor trust each, and then we'll account for each other throughout the process. And sometimes we had one, actually, it was yesterday. Yesterday at 5:00, my partner Tim did it. It was two people. They had separate trusts, but they wanted to be on the call together. And they were accounting for each other. There was a lot they were accounting for each other in their trusts. But we had the call together. We said, hey, we're going to go through both your trusts, but we're going to talk about, how we can make this work for both of you. And that's, again, planning. And it's not the box that everybody fits in, each having a sole grantor trust. Sometimes they're like my wife and I, where we're co-grantor trusts, but we talk to them about what they really want to do. In that specific fact pattern, knowing nothing else, I would tell them each to have a sole grantor trust. We'll work through how we want to differentiate the properties. And again, like we said a bunch of times, as time goes on, if you want to change your wishes, you can. If you want to go from sole grantor, you want to turn it into a co-grantor trust, you can do that as well. Now, if you're unmarried, we don't do co-grantor trusts. We do sole grantor trusts. But in that fact pattern you just gave me, it seems like they had gotten married to one another. We could do a co-grantor trust if they wanted to. I would advise against it given that fact pattern.
And if they're not married and maybe it's a boyfriend or maybe a live-in, friend.
Sole grantor trust. You can account for your boyfriend, girlfriend for sure. There are some legal nuances too that go into not being married, and you can't file joint tax returns, things like that. So you create a lot of nuance there. And let me tell you, I loved my wife when she was my girlfriend too, before she was my fiance. But if I put her on my trust together and I passed away, she broke up and her new boyfriend was driving my car later on, I'd be really pissed off. So I would have had to haunt them from the grave. But it complicates things. The law really doesn't like it. There's a lot of nuance there. If you're married, co-grantor trust, we can do it. But married individuals, a lot of times they come from families, they have different sets of money and inheritance, and they want to account for things differently. Maybe they're not meeting eye to eye on what they want done with their side of the proceeds. That's fine. We can have sole grantor trusts. And when you pass away in a sole grantor trust, your wishes become irrevocable.
Yes. And I love that it becomes irrevocable once you pass. So everything that you put into place and that you put into stone, no one can change because you have already put your wishes there. And now it locks in, like you just lock away the little vault there.
The law is hoping to help see through the intent of the grantor. They want to make sure that your intent was something, to be done with your properties, and they want to see that happen. So, if you're a sole grantor trust, you pass away, they don't want a trustee or a beneficiary to decide what happens to your intent. Your intent was locked in place. You have this legally binding document that says, this is what I want done. When you pass away, that's locked in the stone.
I absolutely love it. Thank you so much, Mo. You're just a breath of fresh air with all this knowledge you have.
You're too kind. It's just doing my job, but I do enjoy what I do. And I enjoy the synergy between real estate, businesses, estate planning, and just figuring out what to do for people who need it. Because again, the average person just has no clue that they need it. And when they find out it's time to, have to do all this, sometimes it's really late in the game there. And again, don't sleep on the fact that the medical side of things is important too. I can't labor that enough. your assets are definitely important. We want to make sure they go to where they need to go. But a lot of people end up in the hospital and come back out again. You want to make sure your wishes are met. You want to make sure your affairs are kept afloat. I'll give you one example before I go. What happens if you end up in the hospital for 2 months? You don't have a power of attorney in place. People miss your bills. Now you come out of the hospital, you're alive still, but your credit's impacted because people didn't pay your bills for you. That's rough. That stinks. Let's not let that happen to you. Get a proper plan.
That's very tough. Very tough. I'm very thankful for the collaboration with you and with Integrated Trust Systems and with the Alliance and with Inspire for Greatness. We've all collaboratively pulled together, each of us 4 or 5 different entities pulling together to make sure that the community is taken care of. And I am very grateful for your guidance and for your knowledge and for always being very, very transparent. Thank you so much for helping us in everything that you do. Ladies and gentlemen, if you are here with us and you're still with us, still look down into the comments of this particular session. It was an amazing, amazing question and answer session with our legal counsel, Mo. He is absolutely on top of his game with estate planning. And even don't forget about those custom directives that may be very important in your lives. Like if you have something specific that you need help with, or even special needs like myself, well, we had to make sure we had those extra things added into there. So I wanted to say thank you so much for being here with us. I got some thank yous coming in right now. They're saying thank you for answering their questions, Mo. And we will make sure that we put the guidance code here. We'll put the link down here for anyone that may have additional questions, want a one-to-one consultation. Or if they say, I don't need a consultation, I just want to get it done. You also have the Integrated Trust Systems link in the bottom of the comments and the input advisor code where you will work with myself, Integrated Trust Systems, and also with Mo for your estate planning in the future. Thank you so much, Mo, for being here with us. Okay.
You're welcome. Thank you for having me. Great to see you. And again, if anybody has any questions, let us know. Send me the link. If there's comments in the comment section, I can answer them in real time. I'll type up some answers for you guys if we miss something, and happy to be a part of this.
Absolutely. I'll send you that comment section as well. Guys, this has been yet another fun-filled financial literacy session, guys. I'm so thankful that you were here with us here on YouTube. The ladies in real estate, you asked for this. We went ahead and make sure we delivered for you today. And I'm so glad that we answered the questions that you've been asking in the chat boxes. And also for anyone that is not in the ladies of real estate, if you are a gentleman or a husband and wife, or even a business owner, these still apply. We'll be more than happy to assist and help in any way that we can. Thank you so much for being here with us, and we'll see you next time with Inspire for Greatness.